Under the Stark Law, physicians can't make referrals to entities with which they have a financial relationship. In addition, under the False Claims Act, or FCA, entities may be civilly liable for knowingly submitting false or fraudulent claims for payment to the federal government. In United States ex rel. Drakeford v. Tuomey, the Fourth Circuit considered whether a hospital violated the Stark Law and the FCA in a case involving employment contracts. Tuomey is a nonprofit hospital located in Sumter, South Carolina. Around 2000, based on its attorney's advice, Tuomey began negotiating part-time employment contracts with local physicians, including Michael Drakeford. Under the contracts, the physicians were paid salaries that were adjusted from year to year based on the amount they collected. Further, under the contracts, the physicians were paid through a productivity bonus, which was 80% of their collections for the year. Drakeford refused to sign the contract, believing that it violated the Stark Law. Tuomey and Drakeford then sought the advice of a neutral attorney who advised that the employment contracts raised significant red flags regarding the Stark Law. Ultimately, Tuomey continued its negotiations and 19 physicians entered into employment contracts. Subsequently, Drakeford brought a qui tam action against Tuomey in federal district court. Drakeford argued that because the contracts violated the Stark Law, Tuomey knowingly submitted false Medicare payment claims in violation of the FCA. The government intervened. During trial, the government sought to admit the deposition testimony of Tuomey's senior vice president into evidence. Tuomey objected, claiming that the testimony included recollections of conversations between the vice president and an attorney, which was inadmissible hearsay. In response, the government argued that the testimony was admissible to show Tuomey's state of mind and intent to violate the Stark Law. The court sustained the objection, and the jury returned a verdict concluding that though Tuomey violated the Stark Law, it hadn't violated the FCA. The government then moved for a new trial, which the court granted. At the new trial, the judge admitted the deposition testimony. The jury then returned a verdict for the government, concluding Tuomey violated the Stark Law and FCA. Tuomey appealed to the Fourth Circuit.